दीदी साहब आपने भी जिक्र पर्दा नशीन वुमेन का तो किया था, लेकिन देर आर ऑल्सो स्पेशल कैटेगरी से रिलेटिंग टू women in general, children, handicapped persons, or senior citizens, old, infirm. Would you like to throw some light as to relationship of police officials with such category during the investigation stage?
The general instructions to the police by way of DGP circular orders, the manual of government orders, as also the criminal procedure code, I take you back to 154, 160, that yes, special consideration in respect of those physically challenged, women of any age, men below 15 years of age, and also above 65 years of age. The physically challenged also, they will have to be examined at the place of their residence and not at the police station unless they choose to come to the police station on their own. Then section 47 also empowers and directs the police that in case of searches and raids, take pains to ensure where it is customary that the women are parda nashin, please give advance warning of the fact that the police are coming. Under any circumstances when you are going, please ensure during the course of searches and raids and interrogation that you are wearing your nameplate and your rank. It should be visible to the person whom you are searching. I take you back to section 46 of the Criminal Procedure Code that women will be searched by women only. And also, if women are to be arrested, they shall be arrested. It's not will, it's not discretion that is given. Between dusk and dawn, that is between the daylight, they will not be arrested before dawn or after dusk. And if there is a compulsion that they have to be arrested, the reasons thereat will be reduced in writing by the IO, take magistrate's order, and then that will be arrested. And when that woman is brought to the police station, it has to be ensured that a woman police officer is present in the police station. If it matter pertains to a sexual offense, 154 onwards, all statements shall be recorded by a woman officer. 154, 161, 164 by a lady magistrate. Then we come to the fact that 164, there are also other provisions. Arrest, search, recording of statements, and also when brought to the police station. I take you to section 237 of the Criminal Procedure Code, first 164, that the statement given before a magistrate on oath, Kalambadh Bayan, would have the same significance as it will have as an examination in chief. Then I come to section 237 of the CrPC. It says that a woman below 16 and also victims of sexual violence will not be confronted by the accused who happens to be accused of a sexual violence. 237 of the CrPC. 357 of the CrPC says, sir, that all medical colleges, all medical institutions, all hospitals and primary health centers, when there is a report or a complainant comes of sexual violence or a sexual case, they shall attend to it on a priority, give all treatment free of cost, and number 3, inform the local police immediately.
Okay. Now, just a supplementary resulting, you mentioned about a circular from the DG. Does it mean then the procedure will differ from state to state?
No, it does not. All the circulars are there, or manual of government orders are there to reinforce the spirit of the amendment, whether it's 13th Criminal Law Amendment Act, okay, or the guidance or the guidelines given, yes, by the Supreme Court, or the guidelines coming after the Human Rights Commission. So all the things, the Human Rights Commission, they will prescribe the board, the particular, yes, board has to be put outside every police station, explaining the constitution and the legal rights of the arrested person and the norms. So that the moment a person comes, he should realize that these are his constitutional rights and they should be. Therefore, when the DGP circular comes or the manual government order comes, they incorporate, and in totality, you understand, police, okay, force is a huge force and it is beyond, I would expect, of course I do, they are highly educated boys and girls. But to make things more simple, to give a checklist, incorporate all the instructions, Honorable Supreme Court, the amendment of law, and also other case laws to be made simple, incorporated, and a checklist made out. The purpose is to make things simple and doable.
Okay. Now, you mentioned about the constitutional and legal rights. Connected to that is the provisions relating to access to a lawyer at the stage of a witness, suspect, and accused.
At all stages, if a person is arrested, when you come, access to a lawyer comes only when a person is arrested. There would be minimal need. Before that, the person is at free. It's only when the liberty of the person is circumscribed by the arrest, that is the time when he has the requirement of the lawyer, the maximum. And the denial of a lawyer, again, is an illegal act on the part of the investigating officer. Therefore, he has to be told that if you want, you can have a lawyer. It is displayed on the notice board outside the police station as mandated by law. And therefore, every arrested person has a right to get a lawyer of his choice. And his relations will all be informed that a person has been arrested and lodged in this police station.
Just clarification that before the stage of arrest, that has not reached, during the questioning or interrogation or inquiry by a police officer, can a witness insist or demand that he would like his lawyer to be present?
Legally, yes, but I don't think practically it is possible. And then it is not a legal right that can be insisted upon during the case of questioning and interrogation.
Right, fine. Now, we often hear the terms case diary and the general diary. There is a need to distinguish between the two and the purpose of the two.
There's a fundamental difference. Both are important documents. The case diary is the diary that is kept with the investigating officer, wherein all the details of the investigation, all the steps that I mentioned, Bayanwadi, Naksha Nazri, Mauka, Moina, etc., are incorporated in the case diary. The general diary is a document prescribed under the Police Act of 1861, Section 44, that incorporates all the day-to-day matters pertaining to the functioning of a police station, like arrests, bails given, change of sentry posts, Moina, and there are certain specific entries that are to be made on a daily basis. Nakshan Naukari is the census of the manpower available. Moina Malkhana, inspection of the Malkhana. Then Moina Ehkamat pending 15 roza, inspection of all the documents that are pending for more than 15 days. As also, any crime that happens, the gist of the FIR is entered in the general diary.
Okay.
So the general diary has a specific administrative function and a legal function, so that during the course of investigation, the court may also summon, show me the diary. Why? General diary. Apart from the case diary that incorporates the investigation part, the general diary will show that in the case diary, you say that the person was arrested at 9 a.m. The entry that you show in the general diary is at, say, 4 in the afternoon. What happened in this while?
Okay.
So you can understand
so
the relevance of the general diary.
Supplement and would
Yes.
need to be
Yes.
sort of interlinked. The two.
Yes.
Fine.
Yes.
Now, this was so far with regard to law enforcement. What are the duties of police with regard to maintenance of law and order?
Good question, sir. I would draw your attention to the very important question that you must have heard. 107-16 में पाबंद किया. 107-1163 subsection of the CrPC is there. If there is apparent or imminent apprehension of breach of the peace, a person or group of persons, two people, like there are two groups here, and I have reasons to believe that the animosity is such that they can come at loggerheads and there can be a bloodbath or breach of the peace, I will ask both the parties and challan them under 107-1163 and send the report to the magistrate that they be found. And then the magistrate, in his wisdom, taking into account the earning capacity and the wealth of both the parties, will ask them to give a surety of that amount. And in case of breach of the peace by any party, that amount shall be forfeited. This is what 107-116 में पाबंद किए गए. But the main thing is that one should distinguish between the aggressor and the victim. Aggressor and the aggrieved, they need not be kept on the same pedestal. It cannot be level. One is an aggressor, the other is aggressor. Therefore, if somebody is an aggressor, I am a dabang of my village, I see to it that the dabang is paband for 10 lakhs and the victim perhaps is firstly, he should not be challaned, or if he's done, maybe 50,000 or something. But that depends on case to case.
Must be maintained.
Maintained. Okay. 109 to the CrPC, a report is submitted to the magistrate that such and such person is concealing his presence to commit an offence. Then the magistrate will keep security for good behavior for 1 year. 1010 of the CrPC, that he is challaned again in the same manner, that he is a criminal history for good behavior up to 3 years. 133 of the CrPC, a very important section, that a passage is blocked, maybe by some obstruction, natural or otherwise, or by some busybody or some person well connected, that obstruction shall be removed with the intervention of the magistrate. Then we come to section 144, the most important section, which is Dafa 144 lagi hai. That 144 is regulation of processions, fairs, and other such matters. And that is why the curfew also is imposed in the wording of the section 144. And what is that? Imposition of curfew, as also a regulation. The procession has to be regulated. The way we are sitting, if somebody wants to take out a procession, he first gives an application, then that application is evaluated. Thereafter, sir, a permission is given that not so many persons, they will not carry firearms, they will not raise inflammatory slogans, as you found in the case of the farmers' agitation. And what happened on the 26th of January, everything during the course of 144 that was breached. And curfew, when there are such law and order situations, then all processions and all movement are banned. That is the curfew. The last I would bring your notice is 145. This is the property, and there's a dispute about it. So it is we attach that property. Kurk kar liya. The kurki is attachment, and it is kept in the custody of one allotted or assigned by the magistrate. And when both the parties or the different parties come and produce their papers of ownership and title, etc., it is decided that it belongs to you or not to me, then the court will pass a speaking order that this belongs to you, and therefore you have no right of access, and it is assigned to you. Then that property from whom it is given in custody is handed over to you.
Fine. That has been very well brought out, all these aspects relating to CrPC. I would also seek your comments, and what is your recommendation? At times, the students in law school who are particularly interested in a subject, and in the case of 5-year law course where there are 10 semesters and term breaks, they do internship. Now, with regard to the study of CrPC and understanding of CrPC, out of options of, say, interning at a police station, at a thana, or the district SP's office, perhaps if available to the IG's office, and a Human Rights Commission, state or center, and a prison, what do you think would be the utility of a student spending a month's time at any of these places?
I'm so happy, sir, that you've raised this point. It is like saying that if you want to be a surgeon, just bookish knowledge will not make you a surgeon ever. The taste of the pudding lies in its eating. And therefore, a visit to the police station, not a visit, sir, a stay at the police station and staying there for 2 days. If that is not possible, then a visit for at least 3 days to a police station, 3 days to the office of the superintendent of police, 3 days to the inspector general of police minimum, and prison at least 5 days. That will expose you to the ground reality of investigations, arrests, production before the court. Because whatever knowledge I may have from the CrPC, I could go on that, go to the YouTube, see Rebecca John's YouTube, see Ratan Lal, Dheeraj Lal. No. Unless you see for yourself on the ground level how things happen, that will make you a multiple dimensional expert on the CrPC, and I strongly recommend that this should happen. 1 month would be ideal as an internship, but unless this internship does not happen, sir, my knowledge would be limited only to academics.
And a question which is basic to the discussion that we had, your presentation today, is that according to you, as per your perception, should the teaching of CrPC be confined to the statute as far as law students is concerned by a teacher, or should case law, like you mentioned about Rebecca John or D.D. Basu and very many other cases, they should be sort of accorded secondary place? Main thing is what is contained, the meat in the CrPC.
So the CrPC, it will be incomplete. I would say it will be looking at a system only through one eyes. What does Supreme Court do? What does the Constitution Bench do? What happened in Lalita Kumari versus State of Uttar Pradesh? What happened in the 13th Criminal Law Amendment? Unless we incorporate all the case law, my study of law will be incomplete. The Supreme Court judgments in any case, sir, are the law of the land. And a good student and a good teacher is one who incorporates everything in totality. This is how the law has evolved. That will explain not only one, the procedural aspect, but the evolution, why this amendment is required, why this judgment has come out in the first place, what was the infirmity earlier. And that is why I say it is like eating a meal without salt if we do not take into account the various judgments of the Supreme Court and the Honorable High Courts.
Thank you very much. And your presentation has been highly illuminating. And I think all the law teachers would benefit from this discourse. Thank you.
Thank you very much, sir. You're very kind. Thank you very much.